Atlanta, Georgia. For some time, Liberians in the diaspora, especially the United States, were, out of status. Some were they were either on DED, TPS, or they were in a state of a limbo, not knowing that state of uncertainty, that every time they have to renew their papers, who have to regularize their status at work and everywhere else. Quite recently, it has been signed into law granting Liberians on DED some status that they can, green card status, that will lead eventually to citizenship. But how we go about this, how it all came about, we are here to discuss it tonight. That is called the Liberian Immigration Fairness. With me to discuss this, I have my co-host, Mr. Atty. here. Atty., welcome to Focus on Liberia. Atty. is muted. Mr. C, welcome to Focus on Liberia.
Dennis, I was just saying thank you, and as always, I'm always happy to be here to do what we try to do best for our people.
Thank you so much. Tonight we have a guest who's going to explain all this to us. She's no stranger to Focus on Liberia. She was here before when at a time that the status was expiring and the president granted, I think, 1 year. She was here to break it down. Now the bill has been signed. We don't know what is in it yet. To the naked eye, we see that things are moving in the right direction. But the eligibility, who's qualified, what the process is, and what really it means for Liberian, who's supposed to benefit. With us to discuss this is Attorney Patricia B. Minikon. Patricia, welcome to Focus on Liberia.
Thank you, Dennis. Good to be here.
And we are so glad to have you. You live in the DC area. How's the nation's capital?
It's doing just fine. A little chilly today and windy.
All right. Just for the sake of my viewers, let's begin by stating or saying something brief about yourself so that we get to know you a little better. I know you. Let me give my viewers an opportunity to know you a little more.
Yes. Hi. I am an immigration attorney, having practiced for the last 27 years in the Maryland, DC, Virginia area. I defend clients in immigration court. I file petitions on behalf of clients with United States citizenship and immigration services. And I also help clients who are abroad obtain an immigrant visa to come to the United States. In addition to being an immigration attorney, I'm also an immigration law professor. And I have taught at Penn State University's Dickinson Law School. I've also taught for the University of Maryland system in Maryland.
Thank you so much. And I send it over to my man, Mr. C.
Yes, I don't know why I'm getting muted automatically. Again, I want to take this time to welcome our guests and also our listener in cyberspace. We want to say thank you for joining us. As you have heard, we are here to talk about our brothers and sisters who have been in limbo for some time. Right now, there's a pathway. Very good news for them. They can now apply for their green card so that they can get permanent status and subsequently citizenship. No other person that we could have brought for you who understand immigration laws to break it down for you to understand. So we will go to our guests and ask our guests, our family now can breathe a little bit of fresh air, isn't it?
That is indeed correct. This is a very, very generous bill, very generous. So what does the bill do? It grants a green card as of a Liberian's date of entry into the United States, which means if this is interpreted consistent with how I am analyzing it, most people, if they are granted a green card backdating to their date of entry, would then have the requisite 5 years to become a U.S. citizen. Who qualifies? Liberians living in the US since November 20th of 2014. This applies even if you've been ordered deported and continued living here, did not leave, or if you entered the US illegally, meaning you either crossed over the border or you entered by a means, say in someone else's name, and you do not have a record of entering in your proper name. Now, as with any law, some people will not qualify. Persons convicted of certain crimes or who participated in the persecution of others based on certain grounds will not qualify. There is, however, a deadline to applying, and Liberians have up until the 20th of December of 2020 this year to apply for this benefit, or they lose it. Now, another generous aspect to this law is the fact that family members can apply as well. So if someone is currently the spouse, unmarried child under 21, or unmarried child over 21, whose parent meets all of the requirements of the, I'm going to refer to it as LRIF, who meets all of the requirement of the LRIF would also qualify. So, and that's what I'm talking about. The generous nature of this act is that you have family members qualifying, and then you also have deportation or prior deportation orders not being a problem.
Thank you so much. So
yeah,
that's a lot to chew on right now.
yeah.
So we often hear about DED and TPS. So does this law refer to, first of all, let's backtrack and tell us a little bit about DED and TPS and how they relate to LRIF, that is the Liberian Refugee Immigration Fairness.
Certainly. Excuse me. So TPS, Liberians as a group have been granted TPS at 2 points in time. The first group of Liberians granted TPS were granted TPS because of the Liberian Civil War. The later group of Liberians granted TPS were granted TPS due to the Ebola crisis in the country. Now, the law does not specifically refer to or require persons to have had DED or TPS in order to qualify. So let's keep that point in mind. DED, what happened is for Liberians who had the Civil War TPS, back in September or on September 30th of 2007, that TPS ended and was replaced with deferred enforced departure. Basically, TPS means temporary protected status. So it's an actual status that a person has, though it's temporary. Now, DED is deferred enforced departure. And what that is simply that the person is in the US, they're able to work, but ICE will exercise prosecutorial discretion and not enforce the departure of the person. So essentially, it's not status like TPS is status. It's sort of a immigration limbo where the person can work and they're here with the knowledge and acquiescence of the US government, but they don't have status.
Wow. I didn't know that was the interpretation of that. When I heard that, I'm like, okay, that means this person can be deported at any time. But that the government has knowledge of this person, except that they want to exercise some constraint and not let the person to go. That is good to know. So my next question is, sorry, I'm getting a feedback. Right. Yeah, my next question is for people on DED.
You still get a feedback. Fix that. Why I asked. You mentioned 2014 that people they shouldn't be here, or those that were here from 2014. What happened? Those who here before 2014 and still they don't have that status. Do they?
Oh yes. I'm sorry, they would be able to apply as well. Basically, think of it this way. Anyone who landed in the US after November 20th of 2014 would not be able to, but anyone who was here on November 20th, 2014 and before that date would be able to apply.
And you don't have to be on TPS, DED. Even if you have come here and been living here for the past 30 years illegally, you can still apply.
That is correct. The law does not reference any prior status because the fact is prior status doesn't matter as much in that the law even grants eligibility to someone who has been ordered deported.
I see why you say generous. Liberia Immigration Fairness. Who came up with that name?
It's actually fair.
Very fair and generous. Dennis, am I okay now? No feedback?
Yeah, you're okay now.
Okay, that is good. Let's come to the issue of people in trouble with the law.
Yes.
If there is a Liberian citizen here on TPS, DED, or none of the things that I just listed, but there is some record of criminality, is that person also qualified?
Well, it depends. There are certain categories in immigration law. You have categories of crimes. There's one called an aggravated felony, and it does not necessarily have to be a felony under U.S. law. If you've been convicted of an aggravated felony, you will not be eligible to apply or take advantage of this. There are some other restrictions. So the law is quite clear. The person has to be admissible. The U.S. immigration law has a lot of bases that would render a person inadmissible. So what this law has done is required that the person be admissible and also exempted them. So you may have heard recently in the news a lot of talk about public charge. If someone's a public charge, they can't get a green card. The law has said that even if you are found to be a public charge, you can still apply for this benefit, the green card for Liberians. And what a public charge is someone who cannot support themselves independent of governmental help if they immigrate to the United States. Therefore, usually the person who petitioned for you has to sign a contract with the U.S. government saying that they make a certain amount and will support you. Now, the other ground that prevents a person from getting a green card would be someone who's coming to the United States to work, but does not have a petition filed by an employer. That's called labor certification, where the US government certifies that there's a shortage of labor in the occupation the person is working in. And because of that shortage, the person is allowed to be granted a green card. The third basis that is waived for Liberians applying for a green card under this act is someone who is present in the US without admission or parole. Going back to what I mentioned, that even if the person came in illegally, meaning say they flew into Mexico and crossed the border, flew into Canada, drove across, they would still be eligible to get the green card. If they lack the documentation requirement, going back again to someone who crosses illegally, who comes in without the proper visa or without a visa, all those are waived. But like I said, there are many more grounds, 20 or so grounds that could render a person inadmissible or ineligible to get the green card, one of which is, different criminal grounds. So that, is where this law ends up being very, very generous.
Okay, let's go to the process. I am eligible, as you have stated. how do I apply, and what time do I have?
Okay, so the deadline for applying is December of 2020, December 20th to be exact, of 2020. There is a form called the application for adjustment of status, and persons eligible would fill out this form. And there's a fee. It's it's $1,225. You would indicate the basis. The form has a box that you would indicate the basis under which you're applying, which is the LRIF, and you would mail it to the appropriate mailing address as designated by USCIS. You also, to support the application, for permanent residence or adjustment of status, you will need to include, for example, a medical exam, your birth certificate. If you have family members who are applying based on their relationship to you, they would need to prove that. So if it's a spouse, marriage certificate, if it's a child, birth certificate or adoption certificate. And then you will need photographs. If you want work authorization, you would include that application as well for the work authorization, and you would check eligibility for it, being that you're adjusting your status. That would be the basis for your work authorization document. You can also apply for travel permission, advance parole. A lot of Liberians are familiar with advance parole because people with TPS could apply for advance parole if they had an emergency to travel back to Liberia. So you will also be able to apply for advance parole while your adjustment of status application is pending a final decision. You would include that application. For each of the applications, you need 2 passport photos. So if you're applying for the green card, applying for a work permit and travel permit, you need 6 photos. I think I mentioned earlier about the medical exam. You do need to include a medical exam. I would highly recommend to any Liberian considering filing to just have, even if they decide to file on their own, to have an attorney screen them for any potential ineligibilities, because you are able to apply for a waiver if you are deemed to be ineligible on any ground.
And what would be some of the eligibility for fee waiver?
Well, someone who may have what they call crime involving moral turpitude, you can apply if you have the requisite relationships. So now a lot of the Liberians who will benefit from this, who may have been on TPS, that was granted back to the 90s, would be able, say, for example, if they had a US citizen relative that they could use as a qualifying relative to enable them to file for a waiver. Because even though someone may be ineligible to adjust their status or inadmissible, certain grounds of inadmissibility permit you to file for a waiver if you have a US citizen or permanent resident relative who would suffer. This would have to be an immediate relative, usually like a spouse or a child, who would suffer extreme hardship if you weren't granted the green card.
And still talking about waiver, I know sometimes on income basis, there are possibility for fee waiver. What may be a possibility to some Liberians?
Yes, Liberians can apply for a fee waiver. So usually the person needs to make either the poverty guidelines, which varies depending on the family size, but for one person is usually around like $12,000. So again, the form that you use, there is an immigration form that is used to apply for the fee waiver, and that form tells you what the income guidelines are. Some you can make up to 150% of the poverty guidelines. So, if that's the case, then persons who make 18,000 might qualify. But again, it's something people have to look into.
Thank you. Let me bring in our viewers. If you are just joining us, this is Focus on Liberia. Our guest, Attorney Patricia B. Minikon. She's an immigration lawyer, and we are discussing the Liberian immigration fairness. That's the bill that has been signed into law by President Donald Trump, granting or putting Liberians who were not on green cards on the path to obtain their green cards and eventually citizenship. If you want to join the discussion, please call. The number is being pinned on Facebook, 605-313-6004. The code is 791403. Back to you, Asoni.
Thank you, Dennis. And my next question is, I'm still getting that feedback, Dennis.
Yeah. All right.
I don't know why it's causing it.
Let me read some comments on Facebook. First from Favor, you might say, how can I get this lawyer number? So they're asking for the number. I think your website is minikonlaw.com, correct?
Yes, my website is minikonlaw.com. My last name, law.com.
Yes, I posted that on Facebook, so you can click on that. Amos Morris say, do you apply strictly for citizenship if you were on TPS?
No, you still have to apply for the green card. And that's why the provision that they should be accorded permanent residence back to the date of their arrival is important, because you need to have permanent resident status for 5 years before you qualify for citizenship. So if a green card is backdated to the person's date of arrival, that means they should have their green card would state they've been a resident since, say, for example, they arrived January of 2014, it would say they've been a resident since January of 2014, which makes them automatically have the requisite 5 years to apply for citizenship.
Another question on Facebook here, say, can someone who has returned to Liberia, who was on TPS or DED, they have returned to Liberia, thinking that this thing was like, especially with President Trump coming to power, it was like, this is never going to happen. Let me go back. Can these people come back now and apply?
I doubt it, for two reasons. The first is that you have to have been continuously present in the US since November 20th of 2014. The fact is, if someone returned, they would not have been continuously present, because the only exception is for cumulative absences. I believe it's no more than 180 days, which would be a maximum of 6 months. And the other reason they wouldn't be able to apply is that this is adjustment of status is available only to persons who are already here in the US, as opposed to someone who's applying for an immigrant visa before the US Embassy. Now, the other aspect to this is, because the requirement is continuous presence since 2014, people will have to document that they've been here. So a lot of times the way you document presence here is tax returns, pay stubs, W-2s, your leases, utility bills throughout the year, if you went to school, et cetera. And someone who's been living in Liberia would find it very difficult to document presence in that, with that level of detail if they haven't been here.
Yeah, let me read 2 more comments. Rose Monaco said, thank you ever so much, Councillor, for this great explanation. She calls it great, and I agree. Sekou Dukwe is asking, say, do you apply for an adjustment of status if you came here on a visiting visa?
You can apply for adjustment of status. I guess I'm wondering but anyway, it's not a live show where I can get a little bit of feedback. Yes, you can apply if you came in legally as well. I simply mentioned that it applies to persons who came in illegally, but absolutely, yes, you can apply if you came in legally.
All right, Dennis, I think we have a caller on the line who has been waiting. You want us to bring the caller in?
Yeah, sure.
All right. Caller, are you there?
Hello, caller, your name and where you calling from?
That caller may not be listening to us.
Hold on, I think there's something wrong. Let me check again. Caller, are you there?
Dang it.
All right, let's go to Facebook.
I think the caller is here now.
Go ahead, caller.
Yes.
Your name and where you calling from?
Hello. I'm Favor Numa. I'm calling from Seattle, Washington.
Go ahead. Welcome to Focus on Liberia. Your question or comment?
Yeah, brother, thank you for this show, man. Thank you for bringing this wonderful lady on to give her this explanation. I'm currently going through such problem. I came here on the at the port of arrival, and I was arrested. They said there was some question on my visa, and then I spent like 2 weeks behind bars, and they released me, and now I'm on parole for the past 8 years now. So I don't know if I'm qualified for this program.
Okay, it sounds, so what year did you enter? You said for the past 8 years.
I came in 2011. 2011, December 5th.
Well, someone who arrived 2011 would qualify because you have been residing here since 2014. You continue to reside here from 2011, past 2014. So yes, someone, if you're asking this question related simply to the date of entry that's required, that date of entry does qualify. Now, as far as any other eligibility factors, that's something that has to be done on an individual basis.
So how you say what? How do you spell your Minikon? You say Minikon. How do you call your website? I would like to get in touch with you and see how I can go about my issue.
Minikon Law.
Minikon. How you spell the Minikon?
Minikon, and the office also has a Facebook page which gives you more details on how to contact us. And it links you to our website as well.
And that site has been on Facebook, so you can check it out. We posted it under the video.
Okay, thank you, sir. God bless you guys, man. Thank you.
Thank you, thank you. And we have more questions.
Okay.
Can one apply for a waiver if they decide to apply for a green card and they have financial hardship? Can someone who has been here 1987 apply for citizenship for the green card?
Yes, you can. If you qualify, you can apply for a waiver. It's not a financial waiver per se. It's a waiver of the application fees. However, you do need to be prepared to pay it, because if you're not approved for the waiver, you'll need to come up with the money. And what I would say is, for people who are applying for an application fee waiver, you want to start your application process as early as possible so you can know before the deadline whether you've been approved or not.
What happens after this deadline?
You will know after December 20th of 2020, you will no longer be able to apply for the green card based on the LRIF.
Now, there are people who, because of this status issue, have been trying different ways, and their application is now in process. What happened to them? Can they just cancel, or that process, whatever thing they might have said, can it be used against them?
Well, yes, from application to application, you need to remain consistent, because any prior form that you completed and signed under penalty and certified that everything in it was true will be held against you. All that information will be deemed, will be deemed to be attributable to you. So, if you've said one thing on a form before and you're saying something else now, you will have a problem with the due to the inconsistency. I recommend that people review old forms to make sure they're being consistent. If you're unsure, you need to consult with an attorney to, have an evaluation of your situation completed, because it may be better to just stick with the process you already started instead of filing a second application with inconsistencies.
So how can these people, is this something that they can do on their own, the application process, or they will need a lawyer?
Well, theoretically, you can file for a green card on your own. The benefit of using an attorney is that the attorney is familiar with the law. If it's an experienced attorney, this person has seen, different scenarios, has had to address different challenges, and is knowledgeable about how to address the challenges. More importantly, an attorney can screen your applications before you ever file it to identify any potential challenges and plan on how to meet them. That way, the applicants are not blindsided after they apply and then immigration says, this is an issue or that is an issue.
Thank you. Again, folks in cyberspace, this is Focus on Liberia. We have with us Attorney Patricia Minikon. She is an immigration lawyer, and she is helping to break down the immigration law that has been signed into law by President Donald Trump that is, in her words, so generous to Liberians, and she's here to break it down to you so that you can know your first step, your second step, and so forth. My question to you is that now that we have this law and Liberians are going to be applying, you were talking earlier, if you talk to a lawyer, the lawyer will be able to best advise you. So I guess the next question is, what are the fees that lawyers might be charging? I know it might not be the same fee or lawyer by lawyer, but just for our people to.
Fees by lawyers vary widely. So you could have some lawyers offering free consultations to lawyers who charge up to $500 for a consultation, for like an hour-long consultation. The fees lawyers charge varies by their years of experience, the location. The bigger cities will probably charge, you'll have people charging more. So if you're trying to see an experienced lawyer in New York City or Washington, D.C., you would expect to pay more than, say, going to an attorney in rural Pennsylvania, for example. So yeah, I would say expect to pay between $200 to $300 for a consultation.
And not taking money away from you, the lawyers, are there pro bono lawyers some people might take advantage of?
Well, there are nonprofits who might, be doing this. I'm not as familiar. Some nonprofits do charge a minimal fee. So that's why I said the range could be from free consultation, up to the higher end of the scale. But yeah, there are, there will be nonprofits who will probably do clinics where you'll have volunteer attorneys coming in to, say like a school gymnasium or something like that, or like a hall, and people will come in and, fill out their applications and the attorneys will assist them. However, for a lot of clinics, if it's not like, say, a specific nonprofit, for a lot of clinics, I've participated in those clinics as well. You simply go in for the, say you sign up for 5 hours, you go in, help people for 5 hours, and that's it. Your role in that is done. So if, people attend those kinds of clinics, they would go in, get help completing it, and then they would be told, okay, you need to add your medical exam, your photos, copies of this, your passport, etc. And then they have to mail the application, with the application fee. Anything that comes up after that, they would still need, to find an attorney. For example, if immigration says, we need extra information from you, they would have to handle that on their own. And that, I think, would be the principal difference with someone actually being, say, a client of the nonprofit or a client of the attorney who is handling the case from start to finish, and anything that happens in the middle of the case, the attorney would be handling, or the nonprofit attorney would handle.
Thank
Let's
you.
look at requirements.
You can fix your background. Let me ask this question. Read this from not your
Okay.
background, the background noise. Let me read a comment from one of our viewers. Say, I was married and my husband and myself applied for citizenship, but my husband withdrew the petition. Am I still qualified? I've been here since 1987.
Okay, now when the writer says her the husband withdrew his citizenship, the husband's withdrawal of his citizenship is his case, not okay. If the husband withdrew the petition, she certainly is qualified. However, they will ask her what happened. There will be some inquiry into the withdrawal of that petition to find out exactly what happened. So for someone like that, when they file, I will just paint a scenario. If I met with someone like that, I would ask them what happened that caused the husband to withdraw the petition, because I know we'll need to talk about it. And then I would have them gather some evidence to prove that their marriage was a bona fide marriage, and not something fraudulent, because withdrawal of a petition by a spouse is a trigger, or it brings a case under the potentially fraudulent case classification, just because spouses want to see, the other spouse become permanent so the relationship can have some stability, and the withdrawal of the petition between spouses would indicate that that is not the case.
Yeah, the question I have also earlier, before the feedback kind of prevented me, now that our people need to apply, what are the things, the requirements they should be gathering as we speak before thinking about even applying?
Well, they want to start going through to document their presence in the U.S. since November 20th of 2014. So if they were in school, they want to pull that. Pull their transcripts, for example, because the transcripts show, you attended school, etc. As long as it wasn't, say, an online course, because an online course, you could be anywhere and doing it. They want to start looking to see if they have pay stubs. They want to look at the proof that they have, that if they put these documents down on a table in front of someone, the person, without having to ask them any questions, would know that they were living in the U.S. during those years.
All right. Concerning the person who asked for the withdrawal of the petition, say in case of relationship, so you were married to your husband, and then she's hanging this thing over you. So when they say no money, no honey, so now the relationship is in case of divorce.
Yes.
So this husband want to be vindictive and say, in fact, I'm withdrawing the petition.
Okay. So basically what this person would do is, for the years that they were married prior to separation and divorce, they would gather proof that it was a real marriage. So say, for example, maybe they had a joint bank account they were using at the time. They would go to the bank and say, I need my bank statements, from July 30th of 2014 until, July of 2015. The person would also see if they have any independent proof besides just their word that the person, emotionally violated them, because a threat threatening someone with their immigration status is part of a pattern of emotional abuse. And because of that, they, would be able to prove that it was a legitimate marriage, but it ended due to the abuse. And that person obviously probably hasn't consulted with an attorney because they qualify to file independent of the spouse. Because if a marriage is abusive, you don't need your spouse to file for you. You can file by yourself under the Violence Against Women's Act. And even though it talks about women, it applies to men and women equally. Both, a man can apply under that provision. So all this person would need to do is just document their marriage, was bona fide, document the abuse. If someone else has witnessed it, or maybe they started seeking counseling or told someone, confided in someone, that person could write on their behalf, notarize, the letter indicating that, yeah, they are aware this person was being threatened with abuse of their immigration process.
Yeah, and definitely you preempted that. That's what she said. She said it was an abusive relationship. So
yeah.
Then I will have a Facebook question here.
Okay.
I guess the answer will be yes. The question reads, are those with EAD, work authorization awaiting asylum hearing, eligible to apply?
Yes. If you are in immigration court right now, it sounds like you are eligible to apply. You would still apply before USCIS because that's what the law says. But you probably have an attorney because you're in court, and you usually need an attorney to defend you in court. You need to discuss it with your attorney, and then usually what happens, the attorney would let the judge know that this person's eligible for, the LRIF, and if they've already filed, we provide the receipt to the judge in order to administratively close the case or to terminate the case. But immigration, USCIS is accepting applications now, so people who are eligible and have all of their supporting documents ready should start filing.
More questions coming, and it's along those lines of if I enter the country in January 2015, am I eligible to apply? Let me answer for you. No.
No.
So if a Liberian arrived after November 20, 2014, are they qualified under the law? According to the Act, one must be physically present in the country from November 20, 2014.
Yeah. Just a second, let me refer again. Well, the way I read this is that you need to have been living in the US on November 20th of 2014. If that helps to clarify it any further.
Yeah. Edwin is asking, I was not calling their names because this immigration, some people don't, can one apply for green cards of spouses and children under 21?
Well, it's not so much that the person is applying as the family member is applying. So it's not like it's not like you're petitioning for the family. The family members are just applying based on the relationship if they don't qualify in their own right.
Are asylum seekers eligible under the LRIF?
Yes. This goes back to the other lady's question who said something about being in court, waiting. So yes, if you're applying for asylum, you certainly are able to switch. And I would recommend you do that because A, the asylum process has a wait. B, even if granted asylum, you have to wait a year before you can file for a green card. So just filing under the LRIF, you skip a step and you save a year because you're just applying directly for the green card and don't have to wait for the 1 year.
Yeah, there's somebody here asking a question and you answered that question earlier. The person said, if I'm on a visiting visa, can I apply?
Yeah.
And that's
it wouldn't still be, no, the first question was if he entered because someone who is still on a visiting visa would not have been residing in the US on November 20th of 2014, in that visitors visas are valid only for 6 months, so they would have had to arrive in the US in 2019.
Okay.
Or it's possible that you came before November 20, 2014 on visiting visa and you have not gone back, even though you have not worked, or
Correct.
it may
Yeah.
pose a question with your some proofs, but I think you still can. So Sonia, let me ask you, you are in Minnesota, you know, and this DED thing, you know, is hot in Minnesota. Is the community doing anything to help those, let's say with to find lawyers like Patricia, or to get money, or to have clinics? Are communities around the US doing something towards that?
I would say yes. And I say yes because there are immigration institutions or institutions that provide immigration services here in Minnesota. So my sense is that individuals who qualify based on the law will reach out to those institutions to help them out, guide them, you know, break the law down to them, just as the counselor is doing here. But I will also add, if at all they can't get to the people, they can call us here, focus on Liberia, will direct them to the counselor and maybe other places. And if there are questions we can answer, given what we've been told now, we can also answer the question, but we will encourage them to reach out to immigration lawyer or somebody who is more knowledgeable about it.
Attorney Patricia, Minikon, what services are you offering to help those, you know, who want to apply for this or honor this LRIF?
Well, my office is a full service immigration office. So we are, or I am offering representation. And what representation entails is that my office completes the applications. We provide clients with a checklist to help them document their presence. We consult with them as they go about looking for things, because sometimes people can't find a particular proof. And then we make suggestions, we brainstorm, problem solve. So we suggest what they come up with so that the packet is strong as far as documentation of their presence here. The representation would cover, you know, preparing the forms, supporting the forms with the proper documentations, preliminarily screening the person to make sure there are no challenges, and if there are, coming up with a strategy for overcoming those challenges, and then filing the application. We receive copies of everything. We usually contact clients to find out if they've also received a copy of, say, the receipt notice or whatever other document immigration might send. If they have not received it, we send them a copy. We also track the application. So say if the EAD is taking longer than usual, or the person's current work permit is expiring, or they're about to lose their job, we intervene to try to expedite the process whenever possible. Once we receive the receipt notice, what representation also includes, once we receive the interview notice, what representation includes is the person coming into the office prior to the interview, so I can prepare them. We do a mock interview so that, if there are any explanations that need to be made, say for example, the person's been arrested before, we go over, how they can best explain themselves so they're not so nervous, so they're not over explaining and the point of their explanation is therefore lost, and so that they're not saying too much so they don't dig themselves into a deeper hole. And then finally, representation includes going with the person to their interview. I'm usually sitting in the room when my client is being interviewed. I'm there not so much to answer the question for them, because I've already prepared them to answer, but I am there so that if things start going in a negative direction, I'm able to intervene to try to get it back on track. If the officer is misinterpreting the law, I am there to explain the law and again, get the interview back on track. I'm there essentially to ensure that the client's experience is successful and that it leads to an approval of their green card application.
More and more questions. One is this applied for, I got approved for asylum since 20 years ago, but I never applied for my green card. Can I now apply under LRIF?
The person could apply under LRIF, or they could apply as an asylee. The thing is, what they need in order to apply for a green card as an asylee, if they were a derivative or anything like that, and the principal has naturalized, they would have a problem. So they need to have it evaluated. And I hope your viewership understands that my answer to their questions on this program is not legal advice. They still need to see an attorney to evaluate their individual cases.
That is very, very important to know. What's about age limit? Someone is asking, can a 10-year-old apply for himself or herself without their parent? I don't know how a 10-year-old get here since 2014, but yeah.
Yeah, well, the 10-year-old can apply. There's no requirement. If the 10-year-old independently meets these requirements of having lived here since November 20th of 2014, that would be fine. They can apply on their own. They would, I think, have been 4 years old. So what Dennis just mentioned, how, do they have their passport? Do they have, other necessary documentation? Do they have their birth certificates? But they don't need to, if they independently meet the requirements, they do not need a parent to file with a parent, because they're not filing as a dependent, they're filing as a principal.
And viewers, we want to, I already said that what we are saying, this is not this would not replace talking with your attorney on these matters. One more question from our folks here say, what if I came in the country on somebody else's name and right upon arrival I was put in jail and later released? Am I qualified?
Well, it depends why they were jailed, but I will say you may require a waiver. Coming in someone else's name is considered misrepresentation. Depending on how you do it or how you did it, it might also be fraud. So it could be fraud and misrepresentation. Depends on why you were placed in jail. For someone in that position, definitely you would need to review some of those, or you would need to have an attorney review the papers you were given at the time you were detained upon arrival. If you still have a copy of the paperwork you used to enter, you want to share that with your attorney, because as part of the screening of the case, that is a potential challenge right there. It doesn't mean you're not eligible to apply if you meet all the eligibility requirements, but it means you may not be admissible, or you may require a waiver in order to be admissible. So eligibility for the LRIF is a separate and distinct matter from being admissible.
Please explain the difference again.
Admissibility goes to whether a person can receive a green card, and whether that person falls within classes of or categories that the U.S. has said are people who are not admissible. So for example, a person, a Liberian who has been residing here since November 20th of 2014 and meets all the other requirements, who has tuberculosis, would not be admissible, because someone who is tuberculosis positive is inadmissible. So even though that person is eligible for the LRIF, they're inadmissible because of the tuberculosis. Now, the immigration law provides you can apply for a waiver, granted you're in treatment and you can prove that. So you can apply for the waiver, which would make you then admissible even though you weren't admissible, but you were eligible and remained eligible even though you weren't admissible before the waiver was granted.
And that same can go to criminal offenses?
Correct. Certain criminal offenses can be waived, or you can apply for a waiver if you have the necessary, well, if you meet the eligibility criteria for applying for that waiver. Certain criminal offenses were specified in the law as rendering someone ineligible for LRIF.
So in that case, the individual must first make sure that they get that waiver from the court before they can apply.
No.
Okay.
If the law says a person is not eligible because they've committed a certain crime, then they're just not eligible to file at all. If the person committed a crime, but they're still eligible for LRIF, but that crime makes them inadmissible, then they need to file for a waiver of the crime, which is the ground of inadmissibility. This is very, and you know, just going through these explanations, it can be a complicated and confusing process, especially if someone does not or has one ground of inadmissibility that applies to them. And that's why I said, not just because I'm an attorney, but that's why I said people need to go and have an attorney evaluate their case.
One question here. In case my case have been put on AR, I don't know what AR is, can I apply?
Yeah, I don't know what AR is either.
All right. I came in the country 2013, but out of fear, I went back home voluntarily. Well, the attorney talked about that before. Your presence need to be continuous since 2014. If you went back and now coming back, I don't think you'll be qualified, but you can speak to that.
Yeah, the law says continuous presence since November 20th, 2014. Someone who left before that date would not be able to prove continuous presence.
Yeah, I figured that would be the case. Well, I think we cover a lot. Is there anything that we have not covered that you want to speak about concerning LRIF?
No, I just, you know, I can't stress enough that people want to have their cases evaluated. They want to be evaluated before they begin this process. It's very important that you make sure you don't lose the opportunity to file for this great benefit. However, you also want to go about it in a very smart way and make sure, you know, that you can prove your eligibility, you can prove your admissibility to the U.S. Before you file.
Let me look at people that apply and maybe for one reason or the other, you were denied and your application is still in progress. After the deadline of December 2020, can that case still continue, or if you have to reapply?
Well, what will happen in case, whenever there's a deadline, and I'm speaking from past, you know, experience in past programs, if there's a deadline that says you have to apply by a certain date, you file before that date, so you meet, you know, you apply before the deadline. If you're denied and you appeal it, your original application date will still control. So if the appellate board says that, yeah, they agree with your interpretation and you have overcome the denial by USCIS, then you would still be eligible because you initially applied before the deadline.
Good. And the ARO the viewer was talking about is administrative review.
Okay.
In case I'm on,
what was the question?
In case I was on administrative review, can I still apply?
That when they say administrative review, it's actually out of context because I still don't know what they're talking about. Is it a court case? Is it a USCIS case? You know, administrative review, does that mean it's on appeal? if it's on appeal, yes, they can apply for the green card because it's a separate case. Immigration law allows you to have multiple applications going if you don't already have a green card. So you could say, for example, your mom could file for you, your spouse could file for you, and your employer could file for you. The only thing you cannot do is get a green card after you already have one. So if you have 3 applications going, the first one that is approved to give you a green card would cause a denial of all the others that you filed. So in that sense, you would have, lost your application fees that you paid. And at $1,225, it might be something, a consideration for people. So yeah, I like I said, I don't know what the context of the administrative review. I would definitely need to ask that person a little more more questions to be able to ascertain better what exactly they're referring to as administrative review.
I think the person might have been talking about an application they may have pending now prior to the signing into law of this.
Okay.
I think that's
and
what
it depends. It depends on why the case is under administrative review. So for example, if it's a case where a spouse filed for them and immigration is saying they're not going to make a decision yet, it's under administrative review, it could be on administrative review because they suspect fraud. Now that's something to take into consideration when the person applies for a green card under LRIF, because any prior fraud would make them inadmissible. And they might require a waiver.
All right. Again, folks, in cyberspace, this is Focus on Liberia. And we have with us Councillor Patricia Minikon, who has been breaking down in pieces the new immigration law that's been passed, giving Liberians pathway to green card. Dennis?
Well, I think the question wouldn't just stop, but I'm posting the attorney's website so that you can contact her. So let me read this one last question from Facebook. Are those applying for the LRIF required to pay the filing fees of US $1,225 to the USCIS?
Yes, they are.
Okay. Right, and please don't give your fees to me because I won't be able to help you. So, USCIS. So to summarize, I came with my son. Okay, I lied. Last question. I came with my son legally with K4 visa after arrival. He couldn't get green card because immigration said he was over age prior to getting married, but he was given visa to travel to the US since 2006. That's the end, but
yeah, the son, all other things being equal, the son should be able to apply to get a green card because it sounds like he's lived here since November 20th of 2014.
I came in the US in August 2015 and applied for an asylum in January 2016. Can I apply for the green card? On a LRIF?
Well, that person, yeah, has not been residing since November 20th of 2014. They've been residing since 2015.
So yeah. So in summary, Attorney Minikon just summarized for us. People are just coming and they keep asking the same question over and over. So if you just use 2 minutes of your time to summarize our discussion for the night on law, eligibility, process.
Yeah, so we've been discussing the Liberian Refugee Immigration Fairness Act, which was passed on December 20th of 2019. And what does the act do? It grants a green card as of the date of entry into the US, which means the person would qualify for citizenship immediately. Who is qualified? Liberians living in the US since November 20th of 2014 would qualify even if they've been ordered deported while they've been living here, or they entered the US without a visa, or by any other illegal means. who does not qualify. Persons who are convicted of certain crimes do not qualify, and anyone who persecuted others in Liberia or in any other countries based on race, nationality, religion, social group, or political opinion. That's, and the deadline to apply for a green card under this law is December 20th of 2020, so December 20th of this year. And you always want to do things early because there are mail delays, there are snowstorms, etc. Family members can apply, spouses and children under 21. Children over 21 can apply if their parent meets all the qualifications of the law.
Thank you so much. At this junction, we want to play briefly our African News Roundup.
Okay, you don't still need me on the line, right?
No, just 1 minute, and then we still need you.
Okay.
Okay, we are having trouble with our correspondent there in West Africa to play the news, but we want to thank you so much for your time. It's been very, very rewarding, a very rich discussion. The question will just stop, and Francis Hinase is very educative discussion. So a lot of kudos to you. What if I came 2014 May and went back to Liberia? Come on now, we talk about this. As long as you, okay, if you went back, okay, his question is in place. I came 2014 May and went back to Liberia May and came back in August 2014. Isaac, as long as you are here November 20th, 2014, you are qualified. So we want to thank you so much. Let me have your closing remarks and then we will be ending the broadcast.
Okay, well, it's been a pleasure being here. I already summarized the act, so I won't re-summarize it, but thank you for having me on. It is always a pleasure to serve the community and educate the community about the laws so that they're able to take advantage of these opportunities fully.
Thank you so much. Mr. Sia, your final words.
I want to say a very big thank you to our guests for breaking it down for our people. I think, as she can tell, the people are giving her a lot of kudos. And to our viewers, those of you who miss it, if there's any question you still have, our video will be on YouTube in the next 1 or 2 hours. You can watch it and your questions will be answered because there are a lot of questions our guest was able to answer that maybe you did not get the answer. So we will encourage you to go to YouTube, tab Focus on Liberia, you will see, and also don't forget to subscribe to our YouTube channel. It's Focus on Liberia. Look at the little bell there and click on it. And anytime we upload any of our videos, you will be able to see it. As you can see here at Focus on Liberia, we educate, we elevate, we promote all things Liberia. If you need help from the counselor, she is online. She has a website. She's on Facebook. Type that name, Patricia Minikon, and you will be connected to her. Thank you.
We are
This is how we will close the broadcast tonight. I want to say thank you to Patricia B. Minikon for your time. Thanks to our viewers. And thank to you also, Mr. Sia. On behalf of all of us here at Focus on Liberia, we say thank you for watching. Good night and God bless you.
All right, folks, that will do it for us here. And bye-bye from us here at Focus on Liberia. Thank you for watching.
Good night, folks, and God bless you.